Good morning.
Good morning, everyone. I'm just waiting for the president to come over. Yeah. All right, good morning. This is the Court of Appeal sitting in Bermuda on the 15th of June, 2021, hearing criminal appeal number 1 of 2021, Levince Roberts against Her Majesty the Queen. Mr. Roberts is represented by Mr. Michael Scott of Brown Scott, and the Crown is represented by Madam Director and
Good morning, my lords, Mr. President, Mr. Justice Bell, Mr. Justice Kay. What a pleasure it is to be with you on the internet and Zoom setting. I appear for Mr. Roberts. He's seated in my office.
Right.
My learned, Mr. Roberts is here, sir. My learned friend, Miss and Crown Counsel, Miss Chantal Simons, appears for the Crown. And Madam Director, I'm quite honored to have Ms. Cindy Clark is appearing for the Crown, no doubt assisted by Ms. Simons, who had the carriage of the prosecution of the case below. My lords, this is an appeal from the decision of the learned magistrate in the Magistrates Court a year or two ago.
Well, this appeal is from Justice
Subert
Williams.
I was about to say it is from the it is an appeal from the magistrate's decision that was affirmed by Madam Subert Williams, and so the appeal is against and to her decision, upholding the decision of the learned magistrate. Lord, we make the following submissions on behalf of Mr. Roberts in this traffic appeal involving the issue of driving whilst drowsy, driving whilst falling asleep and causing harm. In this case, Mr. Roberts accepted that he had caused the accident, had fallen asleep. But the gravamen of our complaint is that the learned magistrate failed to properly and lawfully consider what was a defense by Mr. Roberts by way of explanation of why he continued to drive to a point that he had decided in his mind as a driver, driving competently, to drive to a safe point. The learned magistrate traveled over the actual facts of that defense because in his judgment, and he simply dealt with it by rejecting it. He said he found Mr. Roberts not a witness of truth. In that sense, he completely trammeled over his legal duty to consider his explanation, which the law.
Where did he say Mr. Scott was not a witness of truth?
Yes.
I don't recall.
My words, but at paragraph 23, Mr. Attridge found that he rejected the evidence of Mr. And if we go to the record, I can take you to it, my lord. The judge.
He did not say that your client wasn't honest. He said that he continued driving in the knowledge that he was prior to, in fact, falling asleep.
Well, he said in paragraph 9 of his decision, in the court's view, and having had the opportunity to observe the defendant and consider his demeanor as he gave evidence,
That's the point, yes.
not only is his story of consciously deciding to stop to take photographs in his drowsy condition, when admittedly nodding in and out of sleep, implausible, his supposed decision to travel to the public parking area, convenient, located just after the scene of the accident, is belied by certain facts. And then in the last sentence of the same paragraph, Mr. Roberts' contention is simply incredible in the court's view, and I reject it.
Thank you, my lord.
But that's a finding of fact, isn't it?
Yes, it is a finding. That is his ultimate finding. And what we're complaining about is that it was for the magistrate to, well, it's always for the magistrate to make preliminary findings of fact, and then he must make the ultimate finding. But he is duty bound to consider defenses, whether they arise by inference or whether they arise expressly.
But insofar as your client relied upon what he said as part of his defense, the magistrate A, considered it, and B, rejected it.
But rejecting it, it was in rejecting it, my lord, he never, and we can go through, well, I know that in the judgment, you will not find that he traveled over the territory of considering Mr. Roberts's explanation or defense and discharging his evidential burden that he had an explanation as to why he didn't stop. Moreover, my lords, the defense, the prosecution theory that he ought to have stopped or could have stopped at earlier points were equivocal. They led to a zero-sum proposition, but the magistrate adopted it, and her ladyship also affirmed it. The issues that the prosecution relied upon to demonstrate falling below the standard of a competent and careful driver essentially were he ought to have stopped earlier. And we say that that was a lamentable failure to put to base a finding that Mr. Roberts' driving fell below the standard. The decisions that I have want to refer to, particularly Jimenez, and Jimenez in particular, go over this territory extremely carefully and reject the fact that, well, may I put it this way, my lords? The matters that the prosecution ought to have relied, excuse me, ought to have relied were the conditions of the road, whether Mr. Roberts at the time was speeding. For example, in Hill and Baxter, the courts properly considered before Lord Chief Justice Goddard the erratic prior driving of the defendant, whether he was drunk, what were the conditions of the road. There is an almost interminable list of the matters which the prosecution should lay before a court to establish that the decision to drive on, and may I make this point, to drive on to his safe point, which was what Mr. Roberts did, to drive on to that safe point is not determinative. As a matter of fact, my lords, we say that having made a conscious decision, and this is critical, I say to my Lord Justices of Appeal, it's not that in this case, Mr. Roberts drove several miles.
He probably did, Mr. Scott, for those of us who know the area, because he first started feeling sleepy in Padlet, and that was before the South Shore turn. It's some distance from the Padlet traffic lights to Ashwood Park and then on through the S-bends that followed.
Yeah.
So we drove quite some distance.
Yeah, but the authority says that is my Lord Bell, that is a relevant factor, and we know the territory. He begins to feel tired. He begins to feel tired in Paget. He gets up to Brenda's pool, and he's beginning to feel drowsy and is nodding off.
Nodding in and out of sleep.
Yes. Now that is the point that we say that I'm applying the factor that he didn't drive over many miles from Brenda's pool along Ashwood's Park up to Warwick Long Bay turn and then the corner. Now that's not, but I won't argue, I don't make a big point of it. In the authorities, those are one of the operating factors that,
right.
For example, had he been feeling this way from St. David's after he left his point of work, but there's no evidence that the prosecution either brought, nor is there any evidence on the record that the objective factor to inform whether the driving in a sleepy condition amounted to his not driving as a competent and careful driver. But but back to my point, all that the prosecution relied upon was he ought to have stopped earlier. And this is, I've seen in reading other sleepy driving cases, it seems that the prosecution have a theme here. And again, in the authorities, actually, this comes from the record of the transcript of the counsel in the jury trial of Callan Mabry. Again, the prosecution is saying he ought to have stopped earlier. What I'm asking this court to do is, but let me.
The Mabry case, Mr. Scott, as I understand it, was a jury trial. There's no judgment for us to look at, is there?
I was tackled by that very point by my lady. My lord, no, there wasn't a judgment, but
it's not going to help us very much.
The facts help us, my lord. I say with respect, in that the facts adopted from the transcript, which is in the record, the transcript of counsel's summing up talks about very similar factors as in Roberts. The point that Mr. Mabry wasn't in a state of aggressive sleepiness. In our case, we say we were not sleepy. And this is critical to the point about what we assign and attribute to Mr. Roberts in his capacity to form a view to stop in any event, to form a view whether to stop in a setting where the onset of sleepiness comes on suddenly.
It didn't come on, Mr. Scott, that's exactly my point. It didn't come on suddenly. Mr. Roberts was very forthright in his evidence, perfectly honest, and he said that he first started to feel sleepy in Paget.
That's what I mean. I'm not disagreeing with my lord.
Right, and then he said, and I'm reading from page 23 of the record, it was a tired feeling, not sleepy. It got worse as I got to Ashwood Park, knowing that if I pull over sleeping at wheel of car ticket offence, intent was to pull over and rest and had camera with me. Only got tired at Ashwood Stretch. And that's in cross-examination, but in his evidence in chief, what he said was, as I got along Ashwood Park stretch by the guest houses, I started to nod off for a whole sleep. Well,
yes.
And that's when he made a conscious decision to keep driving. So, and it's because of that evidence that the magistrate distinguished the case of Jimenez, which you said you wanted to rely on.
All right. So, my lord, that is and we say, and we firmly challenge that analysis by the magistrate.
What analysis?
The analysis that the learned magistrate adopted of the prosecution's singular theory that he had an opportunity to stop at earlier points. My Lord, my Lord just read from page what of the record? Page 21, isn't it?
I started at 23, but I went back to 22. So 22 is his evidence in chief. As I got close to Paget, started feeling like drowsy, tired, still made my way to South Shore Road. So that tells me that it was before the traffic lights in Paget. As I got along Aswood Park stretch by the guest houses, I started to nod off for a whole sleep.
Yes, and that's how the transcript reads. I never, it's not a big point. The word whole is the first time I'm seeing it in this transcript. But it's important that we look at how the learned magistrate handled it in his judgment. And I think that is found. So what he did in his judgment, my lords, is to rely upon the fact that he had earlier places and points, at least from Paget. We say, though, when he took his decision from the point of having entered into Warwick at Brenda's Pool and just before Warwick Long Bay, that was the magistrate failing to make a decision about the defense raised. My Lord, the appellant is bound to, we say, my Lord, may I turn to my submissions and go over them and raise questions as I go through them. On my skeleton argument, which I filed in hard copies, and I'm grateful to Mr. Kuala for placing them before you. We say that the appellant is, of course, is bound to accept that at trial, the prosecution adduced sufficient evidence to support the conviction for the offense of causing GBH without due care and attention, contrary to 37. On a superficial analysis of the record, it appears that through his own evidence, he admitted causing GBH to the other road user, that was Mr. Wilson. The primary issue, though, my lords, at the trial and point of principle raised at the present appeal is that if the correct legal test is applied to the facts, the appellant's evidence did potentially support a defense, and that despite the strength of the prosecution's case, the appellant was deprived, that is the complaint, deprived of the chance of his acquittal because the learned magistrate failed to apply the correct legal test and as a result failed to fairly assess the critical elements of the appellant's evidence. That was the appellant discharging his evidentiary burden and the requirement that follows for the prosecution to prove beyond reasonable doubt that that defense was baseless. And we say that the prosecution didn't do that. How could they do it if the magistrate also failed in words, and this is Art Simon's in words, to explain to both the court and to the accused why it was that he would reject his defense. It is in this respect of the appeal, and in order to properly consider the narrow complaint in this appeal, respectfully on behalf of the appellant, that I apply, and I wish to apply, my lords, to amend ground one to ground 1A. My lords, I filed a notice of supplementary appeal. I did so to keep things in good order, and I did so only yesterday. But I had foreshadowed, and I am grateful to my Madam Director, Ms. Clark, that for her consent and agreement to relying on 1A. And may I say, this will keep matters short, and I'll stay to my.
I'm sorry, I'm getting completely lost with this. You say in 1A that the magistrate erred because he failed to consider sufficiently or at all the appellant's subjective assessment that he could safely continue to drive
Yes,
to the
sir.
place he intended to stop.
Yes, sir.
But we're not concerned with his subjective assessment.
I
We're
agree.
concerned with whether a reasonably competent driver would have continued or stopped.
And we're not. And I completely concur, my lord, with that statement of law and the statement of law filed by Madam Director in the Royal Society case, that we should not get confused with a subjective test. And I agree. But
You're saying that sorry,
should-
I understood you to criticize the magistrate who said it was an objective test.
well, my lords, all lawyers are going to go through this exercise.
Well, was the magistrate right or wrong, Mr. Scott, to say it was an objective?
He was wrong in that he did not assess the subjective, i.e. the personal explanation of the accused. It is the subjective.
Wait a moment.
Sorry.
When you
yes.
say the personal explanation of the accused,
Yes.
if the personal explanation of the accused is, I thought I was driving carefully, and in fact he wasn't, that is not a defense.
I agree. But if
Well,
he,
since the learned judge found that he wasn't driving carefully, what does it matter that the witness, the defendant, thought he was?
that is not the case, though, with Mr. Roberts.
What is not the case?
That he said he thought he was driving carefully. His case, my lord, is that I intended to drive to a safe point, having become aware that I was not safe driving any
let's assume-
further. No. I'm sorry. No,
If he was aware that he wasn't safe driving any further, then the question was whether he should have stopped. To which the answer is yes.
And he made the decision to stop, my lord.
Well, he didn't. He went he knew that he was getting drowsy considerable time before the accident occurred.
I don't dispute that, my lord, but the complaint is not about looking reflexively back as to he could have.
Absolutely right, Mr. Scott. The complaint is that the
Magistrate did not.
Mr. Roberts' behavior has to be judged against the standard of driving to be expected of the careful and competent driver.
Indeed, yes.
And all the authorities show that if a driver, unlike the Jimenez case, has had not one but two warnings that he was in danger of nodding off, then the careful and competent driver would pull over and stop immediately.
I completely disagree with you with the greatest of respect, Mr. Justice Bell. Two mental occurrences to a driver on Bermuda roads or any roads in the world cannot become the arithmetical test for stopping immediately. This is going into the territory of Chief Justice Goddard for immediate stopping. The better approach in these matters is for the judge and magistrates to make an assessment about whether the driver was at fault for the line of decision-making he took.
Well, he did.
That's what the judge did. Sorry.
Mr. Justice Kay, good morning. He didn't, it may be useful for us to look at his judgment. All that the magistrate did, my Lord Justice, was to say, I find him unbelievable. There is no place in his judgment where he says that I've assessed his explanation, which is his defense, And I reject it as unreasonable. And it's not a question of whether he believed it. The test is, was the explanation capable of...
Sorry, what are you talking about? What are you referring to as the explanation?
Yes, these words in his, Mr. Roberts' words, that I made a conscious decision to pull over at Warwick Long Bay, where it was safe, and to get out of the car and take some photographs. My Lord, if you need me to take it to you, others may have it.
That's a fair characterization of what he said.
Hell, yes.
That he made the conscious decision to...
Page 9, my Lord, President. Sorry.
What?
Sorry. He made the conscious decision to keep driving. He refers to that in chief at page 22. But that's exactly the decision that the magistrate criticizes on the basis that the careful and competent driver would not have made such a decision. And one of the things that we haven't touched on yet, Mr. Scott, but which must be relevant, is the extraordinarily low amount of, or small amount of sleep that Mr. Roberts had had in the preceding 36 hours.
Well, another factor. It is another factor, my Lord, to be taken into account, but it is not a determinative factor. Mr. Jimenez, in the Australian case, had similar, if not in excess, deficits of sleep. And the other authorities that I've read, there are cases where the amount of sleep for a 27-year-old is not determinative of his having fallen below the standard of a competent driver. The case
the point for Mr. Roberts, unlike the case of Jimenez, is that he had had these two warnings that he was in danger of nodding off. And the second could not have been clearer. He was nodding in and out of sleep.
No, well, he says,
that's what his evidence was, isn't it?
Well, if we go to it, he said he felt tired. He drives, and then he's by the time he's at Ashford's Park, he's nodding in and out.
His words in chief were, I started to nod off for a whole sleep. He started to fall asleep. Surely at that point he should have stopped.
I'm going to rely on the Simon. Sorry, I'm going to rely on the Simon. I don't know what's happened to my. I'm going to rely on the Simons, or my Crown Counsel, to confirm to this court that those words need to be clarified.
Sorry,
Simon,
the words need to be clarified?
Yeah, the fact that the appearance of the word whole, but the appeal shouldn't turn on that. The appearance of the word whole first appears in this transcript. Remember, this transcript was listened to by the transcriber and made a...
Right. And that's on page 22 of the record. I started to nod off for a whole sleep. And then at the top of page 23, the second paragraph, what he says is, sensation of falling asleep as I was coming along Ashwood Park stretch, I was nodding in and out. Well, if that's not a clear indication that he should pull over and stop, I don't know what is.
But I ask my Lord Justice Bell for your guidance on this. When you say should stop, do you mean stop immediately, wherever you are?
Absolutely.
Yes, all right.
Which is what Lord Goddard said in Hill and Baxter.
Well, yes, but Goddard has been disapproved of by an English decision.
Yes, but not
later.
Nowhere in the cases, and I have read them, Mr. Scott, yes, is it said that Lord Goddard was wrong to say that where a driver has received the sort of warning that Mr. Roberts received, that he should pull over and stop.
No, well, again, my Lord Justice Bell, in Gosney, Lord Justice McGaugh said just that. He says, with the greatest of
Well,
respect.
you can no doubt take us to Gosney, but I reminded myself of it yesterday, and that's not what Lord Justice McGaugh said.
But let's look at it. I'll take my lords to it. I think it's on my friend.
It's tab 3 of the authorities.
Thank you. So this was a case where, as we all know, Miss Gosney unfortunately drove down the A1 in the wrong direction. And she gave her explanation to the court that, and she brought plans to say it was a mistake on her part because a reasonable and competent driver was not guided by any signage there at the A2. But taking up the matter on the judgment for Justice McGraw, at A, page 680, when dealing with the whole question of strict liability, the additional words, I'm at H on page 679. The additional words would seem to have been approved, at least implied by the Court of Criminal Appeal in that case. Indeed, such approval is implicit in the statement to safety as an absolute offense. In our judgment, with great respect, it was a development of the law not warranted by authority or principle, and it was wrong. That's and then he goes on to describe fault. I'm grateful that it's up on the screen.
Mr. Scott.
Sorry.
Lord Justice McGaugh is not disagreeing with what Lord Goddard said in Hill and Baxter. If you turn back to page 679 at letter C,
yes,
he says in the former case, that's a reference to Hill and Baxter, Lord Goddard said, no question of mens rea enters into this offence, into the offence. In the context, that means no more than this, a proposition which is now beyond dispute, that the prosecution do not have to prove an intention to drive badly. It does not mean that the offence of dangerous driving can be committed without fault on the part of the driver, i.e. there must be fault. So there's no criticism of the statement by Lord Goddard that if a driver finds that he is getting sleepy, he must stop.
So, but at E, my lord, he says that we reject the suggestion of counsel that there is some subtle distinction in this respect between the offense of driving without due care and attention, and on the one hand, and dangerous driving on the other.
Well, of course there is, but that's not relevant to this case.
Well, my lord, I hear my Lord Justice Speld's view that in the law, the Goddard principle of strict liability is alive still. I think that's.
No, I didn't say that, Mr. Scott. And as Lord Justice McGaugh said, it isn't a case of strict liability. There has to be fault proved.
I'm grateful. That's the only point I wish to rely on.
But a relevant fault can be driving without due care and attention, even though subjectively, if we must use this word, you think that you are driving with due care and attention.
My lord, you're back to that again.
I know, because it's relevant each time.
Well, in this case, the narrow analysis has to be not whether, because it's not on any of the facts. The narrow analysis is of why Roberts decided, after the warnings that Mr. Justice Bell has pointed out, 2 of them, why he continued driving after those warnings. those physical warnings. There is nowhere in the evidence or the evidence in chief that he said, I thought I was driving competently. We mustn't project onto him that manifestation.
So why did he continue?
As drivers do, my Lord President, as drivers do, and as humans do, he made a decision to continue driving to a point that he decided in his mind was the best place and safest place to stop.
Well, there were lots of safe places, Mr. Scott. From the Aswood Park area, he could have pulled over to the side of the road, and he admitted as much when he was cross-examined before the magistrate who dealt with that, because he referred to the fact that these were places for for residents to park.
That's right, the Breakers Club. But my Lord, a defense can't be assessed. A defense can't be assessed based on the negative proposition of he could have done this or could have done that. That is entirely equivocal in my view.
Well, it can be assessed, because if the position is that he could have done something,
yes,
which would have avoided a serious injury and didn't do it, that may well lead one to the conclusion that that which he could have done, he should have done, because any reasonably competent driver would have done so.
I believe that, my Lord, let me look at I hear what my Lord President is saying. You're doing this, my Lord Justice Bell and my Lord the President, that's what you're doing now. This is the complaint that we have, that the magistrate did not do this.
But he did do it. I mean,
He absolutely did it.
Give me a moment. Go to Record of Appeal, page 14, paragraphs 22 and 23. The learned magistrate said at 22, if, as the authorities confirm, a trier of fact is entitled to infer from the fact that a driver falls asleep, that prior to falling asleep, he or she was aware of doing so and ignored the obvious dangers in continuing to drive. In this case, the defendant in his own evidence acknowledged that he was aware of the fact that he was falling asleep shortly before the collision and still continued to drive, even when he had the clear opportunity to stop before the collision, and whether to stop would have been a hassle or not. In all the circumstances, and for the reasons set above, the court is satisfied beyond a reasonable doubt, so that it feels sure, that the defendant was driving without due care and attention. Further, the court is satisfied beyond a reasonable doubt, so that it feels sure, that Mr. Roberts continued driving in the knowledge that he was falling asleep, prior to in fact falling asleep, was sufficiently contemporaneous with a grievous bodily harm as to be regarded as the cause of that harm. That's precisely the analysis which the learned magistrate was bound to do and did do.
Mm-hmm.
And that's completely with Gosney.
Yes, my Lord, none of that amounts to the learned magistrate assessing whether Mr. Roberts's explanation was a reasonable one or not.
He rejected it.
Well, the rejection is not considering it.
Of course it is considering it. It's exactly what he did.
No,
He found at paragraph 9 that Mr. Roberts' contention was incredible, and he rejected it. He considered it before rejecting it.
No, but my Lord, he was rejecting he looked at Mr. Roberts's demeanor, and said he rejects all of his evidence.
No, not all of his evidence, but his explanation as to why he didn't stop.
Well,
he didn't reject all of his evidence.
And he couldn't, my Lord.
No, and he didn't. But what he did reject was the explanation as being a satisfactory explanation, which indicated that he'd acted competently. He rejected the explanation and decided that he had acted incompetently.
He didn't say any of that. We're saying it now.
Yes, he did. He said that rejection in terms of paragraph 9 and incompetence of paragraph 22 and 23. You keep on saying that he didn't decide it, but that's precisely what he did decide.
And indeed, Mr. Scott, in the second half of paragraph 10.
Paragraph, which of the record, my lord? I'm sorry, I'm not.
Sorry, record of appeal, page 9. This is the judgment of the magistrate.
Thank you, sir.
The second half of paragraph 10. The magistrate reminds himself that even if he rejected this aspect of the defendant's evidence, he mustn't jump to a conclusion of an automatic finding of guilt. Rather, I must go back and carefully scrutinize the totality of the evidence in this case, and then consider whether, based upon the evidence that I do accept, I'm satisfied on a reasonable doubt as to the guilt of the defendant. So he did that exercise. He didn't just find that he rejected what he called the incredible and implausible reasons put forward by Mr. Roberts. And then he went on to finish with the passage my lord has already taken you to.
Mm-hmm. Yes, that's the learned judge, but the magistrate enthusiastically applying the legal principles relevant to the offense, but he failed to adequately consider the central complaint raised by the appellant, that the magistrate did not apply the correct test. As a result, I'm on paragraph 5 of my submission. I think I should get through them. Paragraph 5. First, we say the learned judge analyze the legal principles applicable to the relevant offense, but with respect, the learned judge failed to adequately consider the central complaint raised by the appellant, that the learned magistrate, Mr. Attridge, did not apply the correct test, one, and as a result deprived the appellant of a fair trial.
Well, wait a moment. You say
With
the judge's task was, just a moment, the
Yes.
judge's task was to consider whether the trial judge assessed the evidence applying the correct legal test. It is clear that he did not.
Yes, sir.
What was the test that you say that he wrongly applied? He decided that he must determine whether he was satisfied so that he felt sure
Yes.
that the standard that the driving had been below that of a competent and careful driver.
Yes.
That is the test which he applied.
What is? Let me to answer my Lord President's question. What test did he fail to apply?
Yes.
He failed to apply the test to which every accused is entitled to have any expressly raised defense or any defense arising by implication. He failed to apply the test that all defenses, every defense has to be considered by a court.
He dealt, sorry, your client did raise a defense to which the learned judge referred, which in effect he rejected, having carefully considered it and having rejected as incredible an aspect, but not the totality of your client's evidence. Mm-hmm. What more was he supposed to do?
He's supposed to do what, in the case that I rely on in both Art Simons and in Whitehurst.
Sorry, which case?
Both. It's Whitehurst, my Lord Justice Bell, on page 6 of my submission. This is the Chief Justice, the former Chief Justice, Dr. Cayley, considered the extent to which the magistrate has to comply with the Criminal Jurisdiction Procedure. Does everyone? I hope everyone has.
Yeah.
It. In the light of the European decision of the court, of the European Court's decision and Bermuda's own constitution. In that case, then Chief Justice said, the law unquestionably imposes an obligation. So, my Lord, President, there is an obligation, there is a duty on the magistrate to deal with defenses. And
that's
sorry, no, yes, Mr. Justice Bell. There's an obligation, it's a duty. We want the process, yes, an obligation to provide a reasoned decision at the end of a criminal trial. The reason,
which is what the magistrate did. What are we looking at in the record? We're looking at a...
To come straight to my Lord Justice Bell, what the magistrate did was to shut himself out completely, and for my Lord the President, he shut himself entirely out by rejecting the explanation.
Well, he's entitled He's entitled to reject the explanation, Mr. Scott, but he gave it. You can't say that he didn't give a reasoned judgment when he wrote 7.5 pages of very thorough judgment in which he touched on all the pertinent points.
But my Lord President, my Lord Justice Kay and Bell, in the context of sleepy driving, which is something that the world of humanity deals with, the requirement and obligation to discharge that obligation of looking at any explanation, because they are always given explanations as to, there's always an admission that I'm sorry I fell asleep, but if a defendant says, but I was seeking to drive competently and carefully by making a decision to stop at a safe point, we need the court, the magistrate court, and this is what I'm asking this court to review as whether it was a miscarriage of justice that he did not do so. We require in justice for the obligation of the magistrate to satisfy the accused that he looked at the reason of it and decided whether it was reasonable or not. Not whether it was.
He decided it was incredible.
He said it was incredible. That's my point.
Well, I know, but that's what judges and juries do every day of the week.
Mm-hmm.
What you can't say is that he did not consider it. He did consider it, and he rejected it.
Yes, I did. I'm not saying that he didn't consider it. He makes in writing he does consider it. He writes it in his judgment. But what he writes in his judgment, it doesn't come to a consideration of the reason, whether it was reasonable. Whether it was credible is one thing, yes. Whether it was acceptable as an explanation in the context of a person who's
well, firstly, he thought it wasn't credible, which wouldn't, in which circumstances it might be thought you wouldn't need to consider it any further. Secondly, he decided that in any event the behavior wasn't reasonable.
No, I don't. This is where I do not see that. And my Lord President, if you can.
Well, I told you.
What I'm saying is, it's an.
Look, we have shown you, myself and Justice Bell have shown you, I think now on 2 or 3 occasions, where he rejected the aspect of your client's evidence, and B, the final paragraphs, which make clear beyond peradventure that he considered the question whether or not, in the light of all the evidence and in the light of a lot of analysis of the law, whether or not your client had acted without due care and attention, and came to the conclusion that he had not. I don't understand why you say that wasn't fulfilling his duty, and what you say he should have done.
What he should have done ought to be reflected in black and white.
Yes, well, it is in black and white. The typescript is in black and white.
Thank you, my Lord President. My Lord, I see that that you're firm in your view that the learned magistrate considered the explanation and decided that it was not a reasonable explanation. And I've appealed because I do not see it, and it's not because I'm refusing to. It's not in the words of his judgment. The words of his judgment are that I reject it. It is not for this court to say that rejection is equivalent to I considered whether the explanation was reasonable or not. To reject it is
it's implicit. It's surely implicit, Mr. Scott, in what the learned magistrate says, that he is of the view that the careful and competent driver, having received the warnings that Mr. Roberts received, would have stopped driving.
And he made the decision to do it. He's a security officer who's conscious about getting to a safe place.
It's no good making the decision to stop if you don't actually do so. He didn't make the decision to stop immediately. He made the decision to keep driving to a point further west where he felt that he could
take some photographs.
Yes, but how far? Over what distance? I mean,
it doesn't matter.
Oh, it does matter, my Lord Justice Bell, with the greatest of respect. my Lord the President, my Lord Justice K are living in countries where there are A1s. You will see signs that say drowsy driving stop point. It is often in these large carriageways, many miles up the road to the next pit stop. So I back to Mr. Justice of Appeal Bell's point, and to Jimenez, where it says one of the factors to be taken into account in making an analysis of the reasonableness of his defense is whether he, after noticing drowsiness, drove for many miles.
He doesn't. Many miles is neither here nor there. The difference between the facts of this case and the facts of Jimenez is that, as Mr. Roberts said, he had these 2 warnings, and the suggestion in Jimenez was that it did not, which is why the magistrate distinguished it on the facts. In Jimenez, you can see the magistrate make reference to it in paragraph 14 of his judgment.
But in paragraph, I'm looking at that, is that the Quran could not.
Mr. Scott submitted that the case of Jimenez was on all fours with the instant case. It clearly, in the court's view, is not.
But Jimenez, my Lord Justices, is very much a helpful case. I accept that it being on all fours was possibly an overstatement. But if you read Jimenez, which the judge amply kept in his judgment, if you read Jimenez, it simply gives out explanations as the factors to take into account.
Right.
That's why I put Jimenez before the
right. But the important thing to note, Mr. Scott,
yes.
quite apart, first, Jimenez was a case of dangerous driving, not careless driving. But second, the argument in Jimenez was that the driver had no warning that he might fall asleep, and indeed that he didn't feel tired at the material time. That was not this case, and that's why the learned magistrate said at paragraph 17, Jimenez is clearly distinguishable on its facts.
But Jimenez also says that it doesn't matter whether or not this is a case of whether there's this onset of sleep coming as it doesn't matter that.
You're going to have to take me to the passage in Jimenez where that is said, Mr. Scott. I don't believe that's right.
Jimenez, paragraph 9. The issue, when my Lord Justice Bell has
it. What page of the record?
Mr. Qualo, with your assistance, page 9. All right, I'll do it, my Lord. I'll find it. Page 9 of Jimenez is what I'm looking at. Paragraph 9. I beg your pardon, Mr. Justice Bell.
Page 125 of the Joint Authorities Bundle, Mr.
I'm very grateful, Mr. Thank you, Mr. Qualo. So, and then, my Lord Bell, in paragraph 9, you can see Giorgiani. In the middle of the page, I take it at this point, various matters will be relevant in reaching such a conclusion. The period of the driving, the lighting conditions, including.
Sorry, you're not. I'm not at the right place.
All right, let's get everybody.
I think you're reading from a different paragraph.
I'm reading from. I'm not reading from the record. I'm reading from my actual hard copy that I have. But let's get everybody.
Okay. Well, no, I'm not reading from the record either. I'm reading from Jimenez, and at page 126, I think.
It's the first judgment of. It must be Chief Justice Mason. 1, 2, 3 pages in. This paragraph 12, 13. I beg your pardon, my Lord. Please look at paragraph 13 on my mistake of Jimenez. Then we'll all be good. Paragraph 13.
So the passage starting, it follows that for a driver to be guilty.
It starts defective condition at the top of that page that I'm looking at. It's paragraph 13 over the page, defective condition. It's talking about. So, sorry, Mr. Kuala. So it's paragraph 13 of Jimenez.
Manner of driving encompasses is what I have as the.
That's fine.
Yes, that's what I have.
Yes.
On paragraph 13?
Yes.
What page of the record, Mr. Kuala, please?
At
Page 126.
26.
126 of the authorities bundle.
It's very important that I read this to my Lord Justice Bell. So, of the authorities bundle I have. I don't have a page 126. I apologize.
But
Well,
which
if you-
paragraph of the judgment are we looking at?
We're looking at paragraph 13, my Lord Justice. President.
Well, if we can go to the passage, Mr. Scott, that starts, it follows that for a driver to be guilty, which I think was the passage you were taking us
No.
to.
If we can find the words, various matters will be relevant in reaching such a conclusion. And it speaks directly.
That's in the next sentence. So let me read it for you. It follows that for a driver to be guilty of driving in a manner dangerous to the public because of his tired or drowsy condition, that condition must be such that, as a matter of objective fact, so that's an affirmation of the objective test,
So, yes.
his driving in that condition is a danger to the public. Various matters will be relevant in reaching such a conclusion. The period of the driving, the lighting conditions, including whether it was night or day, and the heating or ventilation of the vehicle are all relevant considerations. And of course, it will be necessary to consider how tired the driver was. If there was a warning as to the onset of sleep, that may be some evidence of the degree of his tiredness. And for the period of driving before the accident and the amount of sleep that he had earlier will also bear on the degree of his tiredness. So the Australian judges there are highlighting all the matters that no doubt led the magistrate in this case to reject your client's case and say that that was the basis for his rejecting the contention.
Thank you, my Lord. My Lord, I thank you for finding the passage out. We actually were on it. But my Lord, if you read on, but so far as the driving in a manner dangerous is concerned, here's the operative words. The issue is not whether there was or was not a warning of the onset of sleep, but whether the driver was so tired that in the circumstances, his driving was a danger to the public. The various matters which bear on that question and the way in which they bear on it should be carefully drawn to the attention of a jury. So this point has to be made. I think it's without disputed on the facts that Mr. Roberts said that he starts to feel tired, Paget, and then by the point in Warwick and Ashford's Park, he's going in and out of sleep. Now, we have to attribute to him, a magistrate has to attribute to him this test or this analysis, how tired he was in his head, how we have to ascribe to him how much, to what degree should we allow him to, both in terms of distance to keep driving or whether to stop immediately. Those are the two prongs. When the onset of sleep comes to him at just this point, it is reasonable that he is accorded the fairness of making of his decision making being just what it was, as opposed to being a decision to hit the brakes and stop the car. Because the point where the tiredness is imposing itself on his mind is somewhere along Ashford's Park, where he thinks he ought not to stop and pull over on the grass to attract attention.
And And Mr. Scott, you couldn't have clearer evidence
Yes.
that Mr. Roberts received a warning sign which would have caused the reasonably careful and competent driver to pull over and stop immediately. If you're nodding in and out of sleep, that should go without saying, I would have thought, that it is too dangerous for you to continue driving.
But we can't.
Any distance.
That's sometimes that it may involve medical considerations.
Yeah, but they're not applicable in this case, are they?
And no, of course not. And what the magistrate didn't do was to analyze whether the point where he was and the point where he decided to stop, whether it was reasonable for him to do so. Now, I think I hear my Lord the President saying, and I think I hear my Lord Justice Bell saying, the issue is to stop immediately, which concerns me because we're right into Lord Goddard territory of stopping immediately.
Yeah.
And,
Well, Lord Goddard was right in 9 cases out of 10.
And you haven't shown us.
If you're nodding in and out of sleep, driving a motor car, you're in effect in possession of an extremely dangerous weapon and should stop forthwith.
my Lord Justice President, I
That's
don't
what
want
that
to take the
means.
characterization of Lord Justice Goddard. Gosney so discarded the Goddard principle. It concerns me that we're raising it from the ashes of the phoenix. I mean, it's important that we know where we are on this point because this happens frequently. Driving drowsy happens to everyone on this screen. None of us stop immediately. We all take decisions. We all decide the press on point. We all do.
But if we all do it, we're all guilty of the offence. But nowhere have I found, and I have read the cases quite carefully, Mr. Scott, nowhere have I found Lord Goddard's statement in Hill and Baxter that if a driver finds that he is getting sleepy, he must stop.
And most of us aren't driving, having had 5 hours sleep on the way back from Miami, spent a day at work with a chew bar or whatever it was he had,
Yes.
and then driving off. I mean, the history of before he started the relevant driving is such that he was poised to be nodding off to sleep anyway.
Mm-hmm. Well, the case isn't the one I sent this morning, and I apologize I sent it this morning, but everyone, I was trying to find Kroom, and I did find Dennis and Waltz. I mean,
Okay.
and I mean, in that case, a magistrate with a driver who had been up baking buns he'd had 36 hours without probation, Mr. Justice Bell, 36 hours, and a beer, and he gave an explanation, and the magistrate accepted it. And then the Court of Appeals said that the magistrate was correct. It is such a human set of conditions that I wish this court to give us as much the intent. Wish to give us guidance, obviously, and I was loath to,
what the learned judge said. I've just opened the case to which you're referring, and on page 34, the Chief Justice of somewhere or other, New South Wales, in the present case, in view of the magistrate's finding that immediately prior to the collision, the defendant momentarily fell asleep and had no warning of his inability to keep him awake, it was, in my opinion, open to him on the facts to conclude that he was not satisfied that as an ultimate fact, the accused had been guilty of negligence.
Right.
So that can be, like Jimenez, just distinguished on the facts. Because he had no prior warning of his inability to keep awake.
Yeah, but the no prior warning has, I wish to repeat, is neither here nor there. That shouldn't be.
It's very much here, or there. That's exactly the point.
But in Jimenez, it's saying that it's not dispositive.
That's a different question. fact that something is not dispositive doesn't mean that it's not relevant. It can't be neither here nor there. If you leave a doctor's house and he says, "I think I must warn you," it seems to me that within 10 minutes you are likely to fall asleep.
And you drive.
And you say, "Oh, I ignore that."
Yes. No, you're wrong. Yes.
Yeah.
Yeah. As in Mrs. Dunn, who had a lethargic condition just as a consequence of her menstrual cycle, and that was regarded just like Goddard, Chief Justice Goddard would regard a person with the propensity for heart conditions.
Well, that's different. If you have a heart condition, you have a heart condition. On the whole, I mean, it may be that you have a particular form of heart condition is careless for you to drive at all, but assume that you don't fall into that category. If you have a sudden heart attack, you're driving along and all seems fine. It may well be a case that you weren't careless. You had no reason to believe that you'd have a heart attack then.
Yes, you have a defense.
But you did. It's similar as is described as an act of God.
Yes.
But that's not this case.
No, it isn't. No, it isn't. The case.
Can you just help me on this, Mr. Scott?
Yes.
Could we have a look at paragraph 6 of the magistrate's decision? It's at page 8 of the record of appeal. In that paragraph, magistrate says, to his credit, upon realizing what had happened, the defendant, Mr. Roberts, immediately got out of his car, attended to the complainant, called the ambulance service, and took responsibility, telling witness, police constable, "I'm so sorry, I take full responsibility for the accident. I think I fell asleep. I've been working some long hours." Also, the next day, contacted his insurance company to report the accident and once again accepted liability and ensure that the complainant's loss in earnings was provided for by his insurers. Were his insurers, in fact, liable to indemnify him?
Roberts's insurers in burden to indemnify Mr. Roberts?
Yes.
Is that the question? Yes, I think so. I hadn't. It's a very good question.
That's why I asked it. But if they were liable to indemnify him, that can only have been upon the basis that he was guilty of negligence.
The only difference is the standard of
Proof,
proof
yeah.
between civil liability and the criminal one.
Mhm. Were you indemnified? Did they pay you back? I don't know.
I don't know what that means.
I'm not interested in whether he was indemnified.
I
I'm
say
interested
yes.
in whether he was entitled to be indemnified.
Can I just say something?
Just a minute. Well, I say yes, my Lord President. What is your view? I'm very interested in what the court's.
But my view is that he was entitled to be indemnified because he was guilty both on the criminal and the civil standard of failing to drive with due care and attention. But if in fact there had been no want of due care and attention, if the insurance policy was against legal liability, he was not entitled to be indemnified.
No, I agree. Yes, I agree, sir.
You say that he was entitled to be indemnified.
I say he was. I agree with you.
Yeah, but that can only be upon the footing that he had a legal liability. And that can be only on the footing that he acted without due care and attention.
Well, as I've said in my opening submission, he accepted entirely that he was the cause of this injury.
No, that's two different
That's not the
questions.
question.
A, were you the cause?
Right.
B, are you legally responsible? If you have a sudden heart attack, you may not be legally responsible, but you are the cause of the accident.
Yes. But we can't be precluded from, in a case of due care and attention, we cannot be precluded from saying that, and he's not saying that he wants to be excused because, I can't help falling asleep. He's saying that he made a decision. He, as a competent driver, he made a decision, and I want the magistrate to assess my decision to elect a point in the Bermuda Highway to pull over because I knew I was falling asleep, and to test it.
And the magistrate did consider it, Mr. Scott, and found Mr. Roberts' case both implausible and incredible.
Yes, but he didn't consider whether it was an explanation. He did not ever, I know I'll be criticized for this, but I, as a counsel, wanted to see in the judgment the magistrate giving the kind of reasoning that I'm placing before this court, and I place before my lady Subel Williams, that Mr. Roberts has raised an explanation. Explanations ought to be heard, or if they are being presented as a reason for there being no fault on my part.
My Lord President has taken you.
I have
My Lord President has taken you to the passages dealing with that, Mr. Scott, at the end of his judgment, paragraphs 22 and 23. So no need to go to them again.
No,
But
no,
he
my
did-
Lord Justice Bell, with the greatest of respect, I am using words that are completely different from the words of the learned magistrate. The learned magistrate is merely in a diatribe of I reject and what magistrates often do, believe the accused or not. But the law is nuanced to the point that in these cases that defenses, as I've referred to in Whitehurst, I beg your pardon, in Art Simons, defenses must be considered. Constitutionally, he has the right to have his defense considered.
And there were.
That is the point. To my Lord the President, I know, my Lord, you read the words of the magistrate, and you are concluding as a reviewing court that he did consider the defense and rejected it, but it was improper. It was
Why?
improper, or
Why was it improper?
because it was the legal analysis was wanting, having regard to what should be done, as we hear, as I read to the court from Art Simons, from my own submissions.
You read it from a
I read
reference
it
to
from my
Whitehall.
submissions. Yes, as I read from my submissions, yeah, that unquestionably, there is an obligation upon a magistrate to provide a reasoned decision at the end of the criminal trial. The reasons must enable the parties to understand how the court resolves the question which determine the guilt. The question of guilt in this case hangs directly and it hangs irrefutably upon whether the defense is reasonable or not. The question of guilt hangs on it in this case. And we say that the magistrate, with that obligation, did not give those kinds of reasons, decisions, so that this defendant or this court could understand. For this court to say that he read Mr. Roberts's explanation and rejected it as incredible or not believable is not consistent with his giving a fair. First of all, putting in his mind as the magistrate, the defendant is saying, well, having accepted responsibility, my decision to stop at the other place was by misadventure never carried out because I fell asleep. But I had made the decision as a driver on the roads to stop at a point up the road. Now I know the inclination to convict in a case of a driver causing industry is heavy, but the nuanced position of the law is that the defense must be, there's an obligation to consider the defense in a legal way, in a procedural way. And we say that didn't happen.
Right.
Our Lords don't appear.
I think we have your point.
I thank you, yes. So as to and I'll conclude with this, as to the learned judge at the appellate level, of course, we say that her role with respect is not to assess or make an analysis of the facts and decide whether they amounted to guilt or not. Her role was to look at the failure, which I complain of the magistrate, to properly assess the defense, acknowledge the defense. He never used those words, my Lord Justice Bell. To acknowledge the defense raised, it's to embed into his decision a clear statement of his analyzing the explanation as to whether it was a reasonable one in the circumstances of all of the Bermuda facts, the measurements on the road from Aspert's Park to the point of the collision. Was it reasonable for Mr. Roberts to determine that, having determined consciously to stop, that he has raised the defense which the magistrate was bound to consider.
And your case, Mr. Scott, is that when a driver was nodding in and out of sleep, he was entitled to keep driving, and that's what the reasonably careful and competent driver would do. Is that your case?
No, my lord, it isn't. It is, my case is this, that as a careful and competent driver on Bermuda roads, he took a competent decision to stop. He did the right thing by saying, it is time for me to just pull over.
Well, he could. I mean, if you make a decision to stop and don't stop, it doesn't help very much, does it?
Well, it's important in human affairs. This isn't inconsistent with just ordinary human affairs of driving a car. You have to take into account where you're going to stop. Now, not everybody would have had the same mindset of Mr. Roberts. We'll see many explanations where there is a stopping at an earlier point, but stopping at an earlier point is so equivocal. He could have stopped at an earlier point, caught himself and driven on, and still had an accident due to falling asleep. That explanation went and goes nowhere. But to answer my Lord Bell, I'm not saying that driving on after warnings of sleep is a competent set of actions. What I'm saying is that the decision to stop and the conscious decision to stop is the actions of a competent driver. We shouldn't try to examine things that my client never said he was seeking to do. My lord, those are my submissions.
Thank you very much. We are most grateful. I think we'll take a short break now, if we may.
Yes, my lord. For how long shall we?
Well, not less than 10 minutes.
All right, thank you, sir.
We're about to end now.
Are we all here? Yes, right. Well, as I say, we're grateful for all the submissions that we have received. Ms. Clark, we've decided that we don't need to trouble you, and the court will now adjourn, and we will give our judgment in the course of this session, which extends to next week and the week after.
Yes.
Thank you all very much.
Thank you, my lords. My lords, I don't wish to interject on that decision, and I'm not doing that. What I'm asking for my lords to do in your judgment, whoever leads it out, is to help clarify. I don't know if the director has this difficulty to clarify where we are in the world of absolute liability for careless driving involving a sleepy or drowsy driver. I mean, Mr. Justice Bell and my Lord President, Gosney makes it I want my lords to give clarity for counsel and for the.
I think Mr. Scott Gosney makes it clear that fault is a requirement.
That's right, yes. But no, and that absolute liability doesn't apply anymore. I'd like to be able to see that.
That's the criticism of Hill and Baxter, which isn't relevant, I think, for our purposes.
Why, with respect, you say it's not relevant. It's relevant to the fact that even as my lord says, Mr. Roberts should have done what Goddard said, Chief Justice Goddard said he should do, stop immediately.
Nobody approached the case on the basis that it was an absolute
liability.
charge.
All right. Those were that was my observation.
I'm sure we can slip in a sentence which says it's not a case of absolute liability.
I'm grateful.
Nobody suggests it is
All right.
on either side, nor did either the magistrate or the judge suggest it was either. But if you think there's any doubt, I'm sure, as I say, a sentence.
My lords, it's been a very great pleasure to see all of you again after not having been in the Court of Appeal for a while. I'm grateful. My lord, may I thank Madam Director for all of her. She's been of assistance throughout this getting this record together. And Mr. Qualo, thank you, sir.
Yes. Well, I'm very sorry that two of us are not present in person.
Yes.
Speaking for myself, I haven't been in Bermuda since the March before last, and I'm fervently hoping to be in Bermuda this coming November. But the world is so curious.
Yes, yes. But I look forward, and I hope I have the opportunity to preach
that
it.
would be good, but nothing is certain in this vale of tears. So we'll have to wait and see.
Indeed.
Thank you all very much.
Good morning, my lords, my ladies. Thank you.
Thank you, my lord.